So I think there are a couple of ways in which these discussions are valuable. I think you're right. I think it's important to remember the really serious human rights violations that people who come to the U.S. as asylum seekers and as refugees have faced in their homeland, and how serious those violations must have been to push them to flee their home. I think that's really important. I think the other dimension that also doesn't get reported enough are the incredibly thorough background checks that are done on refugees. So refugees who come over to the United States face the most thorough set of security checks, rounds and rounds and rounds and rounds of security checks of any immigrants coming to the US. And then asylum seekers from the very beginning of the process also face serious security checks. So I think both the fears of security threats and the lack of understanding, I think it's important to talk about both of those aspects.
And the good news is that the United States has a very long-standing commitment to the international human rights of refugees. We were heavily involved in the negotiation of the 1951 Refugee Convention, the treaty that began all this in after the Second World War, in response to the failure to protect refugees during the Second World War and Hitler's Nazis, and also in light of the changes that had taken place with regards to the Cold War and the suppression of certain rights by the Soviet Union. So the Refugee Treaty has long been a law that the United States cares about, and so there have been for many years champions on the Hill in Congress who have moved these issues forward. But it has become very divisive, and there is more concern and controversy over some parts of it. But as Jaya said, the security issues, which is the most recent concern that people have, the refugees that the United States selects abroad and brings to the United States, which is a program that goes back to the 1970s. That program, those individuals are vetted more than anybody else. So those issues are, I think, well addressed by the way the government's been handling it. And the rest is about helping people understand people are fleeing terrible human rights conditions, and that's why many of them come. And any of us, if we were in a place where there was terrible violence taking place and we were the ones who were going to be targeted or clearly affected by that, we would do what everybody else does and try to get to a safe place.
The asylum office, I think, is actually working relatively well as a part of the asylum process, but there are obviously challenges there. I think a lot of challenges due to lack of resources, and those challenges are just increasing now as we see increasing numbers of applicants. So I think what we took out of our research and our meetings with both the quantitative and the qualitative research, our meetings with asylum officers, is that like any system, there are probably a few bad apples in there, but by and large, these are men and women who are working really hard to try to protect refugees, to protect asylum seekers coming to the United States, and they're just not being supported in ways that they need to be supported by. So by giving them more time, asylum officers get some training, they could probably use more training. I think there are a lot of different ways. One of the recommendations we had from our prior book, which I really like, that's not actually very expensive or time consuming, is to have the highest granting officers and the lowest granting officers have lunch every couple of weeks, but the asylum officers tell us we don't have time to eat lunch. So I think giving them more time to make thoughtful and careful decisions, and really the real focus of our research is about professionalism of the system all the way through, and just making it as professionalized as possible.
And some of the disparities are in the government's control to address, which is why, based on the data that they gave to us, and the major finding about differences between asylum officers who had a law degree and legal training versus those who didn't, we recommended that one way to address these disparities was to hire those who have legal training, right? And that's something they can handle. But then we discovered other things that really are not so much in the asylum officer world to completely control, unintended consequences of what Congress created. So what we didn't talk about in our show today, but we'll raise here, are the unintended consequences of a deadline that Congress imposed on asylum seekers, that they must file an asylum application within 1 year of arrival in the United States. And we found that there are tremendous disparities among nationalities in terms of which nationalities tend to file, more often on time and which don't. We found gender differences. Our recommendation was that, number one, that it really is not necessary to delimit a time when somebody should be able to apply. For example, people who are traumatized may take years. And we've actually had cases in our clinic where they were able to convince an immigration judge that there were good reasons that it took them 4 years. So we don't know that there's any magic time that works. In our view, the credibility decision that an asylum officer or an immigration judge makes is enough to determine whether or not somebody's got is a viable claim and can be trusted. And we shouldn't be worrying about an artificial mechanism that Congress thought might separate out the bona fide from the non-bona fide, because it clearly doesn't.
Right, and as it turns out, those factors that you mentioned are really, really important, and they connect with nationality, in that those nationalities who already have a large community here in the US and who come, we know that people migrate to where they have friends and family, and they come and they're immediately connected to that community, are more likely to file on time because their community knows to tell them. But folks who either don't connect in that way or don't have large communities here are put at a very serious disadvantage. And that's not what I think any of the drafters of the deadline intended.
And these laws are very complex. They do require lawyers to actually help tell us exactly what happened to an individual. And unfortunately, we still don't have representation required in our system. But it's clear from what we've seen that, number one, it matters a lot in terms of outcomes. And from what we're told by immigration judges and asylum officers, it generally is helpful to have somebody represented because it narrows the issue. What happened is clearer to the adjudicator, and that's what you want to have adjudicator focused on, is the real essential merits of a case.
Right. And legal representation, quality legal representation, can also perform an important function for the court, because what we saw, what Andy still sees, what I thought at Georgetown, is the students spend hours and hours and hours getting out the applicant's story and distilling it into exactly what the adjudicator needs. And as part of that process, we saw every year 1 or 2 applicants would what we call wash out and just not come back, which we always assumed meant that their claim was fraudulent. If you dig enough, and they'll get, probably 1 or 2 weren't, but if you're close enough to them, you can really tell the fraudulent cases. That how can an adjudicator in 4 hours or less determine whether a case is fraudulent? It's not enough time. It's not enough time.